Everyone, and welcome. We're thrilled to bring you this panel today. My name is Arthur Demrich. I'm the director of the LemelsonCenter for the study of invention and innovation at the Smithsonian. Let me do a little bit of background and introduction, and then we'll get into the content of the panel. This is, of course, slightly experimental. We had originally designed and planned this to be hosted at the National Museum of American History on stage, followed by a chance to see some of the collections and artifacts in storage. We planned that last fall. Obviously, things changed. We're delighted still to be able to bring you this program in collaboration with the Center for the Protection of Intellectual Property. Let me start with just two quick logistical points. So everyone, if you're not familiar with WebEx, on your screen in the upper right area is a little circle. And if you click on that, it can show you either grid view or active speaker and thumbnail or active speaker video. So my recommendation is you do active speaker and thumbnail, but you can do it however you like, just to point that out. And second, we are delighted to take questions from the audience. Please type those into the chat box, and then we will get a chance to get to them. So again, I'm Arthur Demrich, director of the LemelsonCenter. This is a center housed within Smithsonian that exists to engage, educate, and empower the public to participate in technological, economic, and social change. So we do a variety of historical research, we develop educational exhibits, we create exhibits in person in the museum, and we host programming like this one to advance some new perspectives on invention and to actually encourage interactions between the public and inventors. So we're, of course, especially thrilled to have Dr. Chakrabarty here today. The panel is part of an occasional series we've been developing with our collaborator CPIP, the Center for Protection of Intellectual Property. And in these, over the course of the last 3 years, we've explored different topics in intellectual property. And in this case, really bringing a combination of the scholarly analysis with practitioners. So we're very fortunate to have Jenny Schmidt, a farmer on Maryland's Eastern Shore, and their perspective into the discussion. So going beyond sort of the analysis of intellectual property into how it works and what it means for people in their daily lives. So the plan is I'm going to introduce the panelists one at a time, and then they will be giving some brief opening remarks. Then I'm going to lead a discussion with them about several key points, and then we'll turn to questions from the floor. Towards the end, Sean O'Connor from CPIP will be giving some short summary remarks, and then we encourage everyone to stay on. We have a special bonus. A curator from the Smithsonian Museum is going to present a kind of virtual walkthrough of some of the exhibit items that you would have otherwise been seeing in the museum. So without further ado, Dr. Chakrabarty is a microbiologist. He earned a PhD from the University of Calcutta in 1965, and then while working at the General Electric Research and Development Center, he engineered a new series of bacteria, new species of bacteria. After pursuing the patent that we'll be discussing, he continued to make advances in the study of bacteria proteins and peptides as a distinguished university professor in the Department of Microbiology and Immunology at the University of Illinois College of Medicine. He's also been involved as a founder of 2 startup biotech companies. Dr. Chakrabarty, over to you.
So shall I read it now? Okay. I want to begin by thanking Dr. Arthur Demrich, the panelists, and all the persons, especially the technical experts involved in organizing this panel, hosted by the Smithsonian Institute and George Mason University. I grew up in a small town called Saintia near Calcutta, India. I came to the University of Illinois at Urbana in 1965 to work for Dr. Arvin Clyde Gonzalez, known as Gunny. After receiving my PhD under the tutelage of Dr. Sailesh Chandra Roy in Calcutta University. This was my first trip to the United States. I had just been married. My wife Krishna was with me. She had completed her graduate studies at the University of California at Davis earlier that year. She worked with Dr. Gilbert Lavelle, and I worked with Dr. Gonzalez for 6 years. I learned about the pathways of hydrocarbon degradation in Pseudomonas. I have remained loyal to the bacterial species Pseudomonas for my entire academic career. So much so that I only have one email address, and it is pseudomo@uic.edu. Dr. Dexter Bellamy, Dr. Gonzalez's former student, recruited me to work at the GE Research and Development Center in Schenectady in 1971. My first project was not very glamorous. I was supposed to utilize bacteria to convert cow manure into more proteinaceous cattle feed. At that time, there was an oil spill on the coast of England. Over the weekends, I started to work on my favorite project. I thought that oil could be broken down and dispersed. I studied degradative pathways of hydrocarbons in Pseudomonas in more details. The degradative pathways were mostly encoded in plasmids, not in the chromosome. If the bacteria lacked food, and if oil is all they had, these plasmids would move from one bacterium to another as a means of species survival. My team and I created conditions so that one bacterial species survived if it had multiple plasmids. Eventually, I had designed a bacterial species which could degrade many different kinds of hydrocarbons in oil. My three associates in the lab were Joan Milroy, Denise Fiello, and Joe Hacker. I had planned to give a talk about these pathways in a meeting in Tel Aviv, but Vice President Dr. Arthur Bicker, who knew me because of my weekend visits, suggested that I apply for a patent first. I couldn't give the talk, but my life changed because of this decision. My supervisor, Dr. Ron Brooks, and his superiors, Dr. John Brown and Manny Evans, helped me a lot because I had no clue about patents. There was a lawyer, Leo Melosi, who filed a patent for the process as well as the product on behalf of GE. 3 appeals later, the patent was granted by a narrow 5-4 vote in the US Supreme Court 40 years ago. My bacterium actually never saw the light of the day and was never used to clean up oil spills. But many other live bacteria and mammals were allowed to be patented. I did not make any money, but I received a lot of attention. I joined the UIC, University of Illinois at Chicago, in 1979 and continued to work with Pseudomonas aeruginosa, a cousin of Pseudomonas butida that thrives on the sticky mucus produced by the lungs of cystic fibrosis patients. Our research group found out that this bacterial species secretes a toxin called azurin, which kills cancer cells. So from digesting oil to fighting cancer, Pseudomonas continues its noble crusade, and I got a free ride. I hope human ingenuity is always rewarded and patents are used to improve the quality of life. Thank you for listening.
Thank you, Dr. Chakrabarty. The next panelist I'm pleased to introduce is Professor Dan Kevles. He's the Stanley Woodward Professor Emeritus of History, History of Medicine, and American Studies at Yale University. He has published widely in the history of science and medicine, including on the history of plant and animal breeding, the emergence of biotechnology as a science and industry, and on intellectual property and the law more generally. Dan?
For organizing this panel and my fellow panelists for joining me in this discussion, and especially to Dr. Chakrabarty. It's nice to see you again, and without whom we would not all be here. So I'm going to speak rapidly because I have a lot to cover. As Dr. Chakrabarty has indicated, in June 1980, the U.S. Supreme Court granted him and his employer, General Electric, a patent on a microorganism, a strain of bacterium Pseudomonas, that he had modified to consume hydrocarbons. The first slide, please, Kevin. Hello? Okay, first slide. All right. And this is from the opening page of the Supreme Court decision. At the bottom, I call your attention to the phrase, the sentence in red, in which the court focuses on the point that the claim that living things are not patentable subject matter. How that came to be is an important feature of this case. The case was highly contested, as many of you know. Both sides incorporated into their arguments a key statutory precedent, the Plant Patent Act of 1930, or for short, the PPA. The Chakrabarty decision, like most legal decisions, does not come from nowhere. It's grounded in precedent. So what was the PPA? The PPA granted patent protection to plants that were asexually reproduced, which meant mainly fruit trees, vines, and flowers, such as roses. That is, any variety of which can be identically propagated from, for example, cuttings. The identical reproducibility of these plants, excuse me, had long posed hazards in the protection of the intellectual property in them of nurseries and individuals who innovated or invested in the development of new varieties. The innovator could easily be ripped off, notably by an unscrupulous competitor who obtained, say, a valuable apple tree either by purchase or theft, then produced multiple copies of it by cloning and sold it as his own under a different name. One might say that an apple tree sold by another name would yield fruit tasting just as sweet. Nursery innovators thus faced a problem in protecting the intellectual property in their fruits, very similar to that faced not so long ago by the producers of MP3 music. What to do? In the half century before they turned to Congress for protection, the nursery business resorted to a variety of private protection schemes, pricing schemes, contracts, and intimidation by private detective agencies and lawyers against would-be rip-off artists. But all these measures fell far short of enforcing an innovator's rights. So the nursery industry thus sought in the first third of the 20th century to obtain legal protection in the form of patents on its innovation. However, it had to overcome a key obstacle, the doctrine first fully articulated in 1889. The next slide, please. That products of nature were ineligible for patents. The reason it being, as the Commissioner of Patents then stated, Mr. Latimer, because the core of the U.S. Patent Code holds that in order to be eligible for a patent, the object must be made by a human being, not by nature. And in this case, the Commissioner of Patents had turned down an application for a patent on the needles extracted from the pine tree. And as you can see, he says there, does not allow patents upon the trees of the forest and the plants of the earth. The pro-patent advocates ingeniously found a way around that obstacle by successfully proposing that patent coverage could be extended to plants that were asexually reproduced by, for example, cloning. Nature did not reproduce fruit trees and vines asexually. So that the advocates persuaded the Congress that therefore a cloned fruit or rose was not a product of nature, but a product of man. May I have the next slide, please? Well, there. So as you can see, here's the Plant Patent Act in 1930. The first anywhere in the world to extend patent protection to a class of living organisms. And to quote the act, it authorizes a patent to anyone who has invented or discovered and asexually reproduced any distinct and new variety of plant other than a tuber propagated plant. And that phrase is there to protect the potato industry. The advocates also managed to satisfy the standard requirement of patent law that a covered invention must be described. Since they well knew that verbal descriptions did not suffice, I'd challenge you, for example, to try to describe a plant or a fruit with sufficient specificity to claim it as your own. It must be described. So they knew that this did not suffice. Verbal descriptions did not suffice. So they incorporated into the law the practice they had long used to identify fruits and flowers, that is, illustration. May I have the next slide, please? So every plant patent had to be accompanied by this kind of drawing. And here is a plant patent on a cherry from the estate of Luther Burbank. And the next one, please. Next slide. Okay, and there is a flower, the rose, also from the Burbank estate. And hundreds of these were produced in connection with the patent application. Finally, to return to the Chakrabarty case. The leading opponent against granting Chakrabarty a patent on his bacterium was none other than the U.S. Patent Office itself. During much of the course of the case, its opposition centered on the claim that the bacterium was a product of nature. As the case progressed, however, it added an additional ground of opposition that patent protection on a living thing required, as it had with the PPA, an act of Congress. And the reason that the issue of the patentability of something alive came into it comes right out of the social and political upheaval of the late 60s and into the 1970s. And the Patent Office basically alludes to all of them in making this, enlarging its reasons for opposing the patent. Chakrabarty's numerous allies stressed that his bacterium was not a product of nature, but a product of Chakrabarty. Moreover, the core of the patent code declared and continues to declare in language written by Thomas Jefferson that patents cannot be granted for, quote, or can be granted for, quote, new compositions of matter, unquote. Unlike the progenitors of the PPA, Chakrabarty had modified and could specify the chemical composition of this bacterium by modifying its genetic characteristics. So it's a new composition of matter. In a sense, it's a new chemical. Finally, the proponents argue that no special new legislation was required to extend patent protection to living organisms because Congress had already established that principle in the Plant Patent Act. In the end, the court sided with Chakrabarty by a majority of 5-4. Holding that whether an invention is living or not is irrelevant to its eligibility for a patent. May I have the next slide, please? And as you can see here, it invokes the Plant Patent Act precisely on this point. Forget about that Plant Variety Protection Act and there was something else. But it says that the Plant Patent Act authorized protections for certain sexually reproduced plants, but excluded bacteria from its protection. The fact that does not evidence congressional understanding that the terms manufacture or composition of matter in Section 101, that's the core of the patent code, do not include living things. So whether something is alive or not is irrelevant to eligibility for a patent. The decision aroused widespread economic and ethical controversy, including predictions that it would usher in the commodification of even higher organisms, some of them perhaps monstrous. We have them next to the last slide, please. Here you see a commentary from her block in the Washington Post, where the patent examiner is saying, I'm sorry, he's holding on to Frankenstein. That's not exactly what the Supreme Court ruled on. In fact, during the 1980s, the decision did enable the patenting of not only other microorganisms, but also of sexually reproduced plants and of animals. So the Patent Office did draw the line in 1987 at the patenting of a special animal that is us, human beings. We are to date not patent eligible. Thank you.
Thank you, Dan. That was wonderful. I'm pleased now to introduce our third panelist, Jenny Schmidt. Ms. Schmidt is a third-generation farmer on Maryland's beautiful Eastern Shore. The family farm grows tomatoes, grains, vegetables, and wine grapes using a technique they call synergistic farming, which draws on diverse farming methods to create healthy soils and sustain healthy food production. By background, Jenny is also a registered dietitian and worked previously in hospital-based clinical dietetics. She's an active blogger and commentator on farm issues. So Jenny, we're kind of inviting you to comment on the experience of, pros and cons of using genetically modified seeds and crops. So welcome.
Thank you. Thank you, first of all, for the Smithsonian for actually having a real farmer on the panel. It too often is overlooked, so I really, truly do appreciate that. So just by way of a little bit more background for the viewers on our farm, we are a large farm by definition in the state of Maryland. We're about 2,000 acres. My father-in-law made some very wise land purchase decisions back in the 40s and 50s when land was 25 bucks an acre. So we're fortunate to be in the position that we are in. We are very diversified in terms of crops and also diversified at one point anyways in terms of farming systems. And by farming systems, what I mean is whether or not something is biotech, if something is conventional, or if something is certified organic. And at one point, we did all three simultaneously. So when I talk about farming systems, I'm talking about basically a system of management tools that are used in each of those different farming systems. But there is a lot of overlap between all three different systems. Currently, we do raise biotech crops as well as what we would call conventional crops. There aren't genetically modified tomatoes or green beans or grapes on the market, so those would be some of our conventional crops, as well as what we call a non-GMO soybean, which is made for tofu, and that's more of a conventional crop. And for us, that diversification is all about risk management, not having all your eggs in one basket, so to speak, from a business decision. So my father-in-law was really the one who brought in sort of the biotech traits into the farm back in 1998. So the first biotech corn and soybeans were commercialized back in 1996. So he would be considered somewhat of an early adopter of the technology. We started out with 10 acres of corn. So that was our test plot to see how well did they compare to what we were doing otherwise on our other acres of corn on the farm. I would say that my father-in-law was a very progressive farmer. He started no-till farming and doing cover crops back in the 1960s. We have Farm Journal magazine from 1965 with him doing no-till corn. So trying new things was not unusual for us on the farm. And having said that, I think one of the things that's really interesting about how rapidly biotech traits and biotech seeds were adopted by farmers really is interesting from what my father-in-law said several years ago, which was he lived through the process of adopting hybrid seed. Hybrid seeds came out in the late 20s, early 30s, and took decades to be adopted. It really wasn't widely adopted hybrid corn until the 60s and 70s. So it was a much longer adoption process for quote unquote a new breeding technology in crop production. So for him, thinking about the biotechnology traits Roundup Ready or BT technology in any of the seeds was almost sort of he would call it a no-brainer, because he had already seen the benefits of the new hybridization technology, and therefore, just proceeded down the next opportunity of what was available to us in terms of technology on the farm, and looking at how does that compare to the impact of our practices, our sustainability practices, our ability to do conservation. When we do use sprays, to be able to use something that is less impactful on the environment than some of the older chemicals, the older formulations of pesticides that are on the market. And so it really was looking at as a management tool, and as, a lot of times what happens when companies are developing new hybrids of seeds, they're putting in the best genetics in those seeds. So for example, we have dicamba soybeans on our farm. We don't spray dicamba on them, but because they are the newest seed on the market, they have the best genetics. So they're going to have the best yield. And so that's one of the things that we look at, whether or not we use the technology on our farm. It's also looking at what are the other traits that come along with that technology that have been brought into that crop to begin with. So those are sort of the decision-making processes that we use when we're looking at those types of things. And so for us, predominantly, I would say 80% of our grain acres, meaning corn and soybeans, are biotech. And then I'd say about 20% of our acres are conventional or non-GMO. It's not a term that I really like to use, but that's what the consumers generally understand. When I say conventional, they actually mean sort of not been genetically modified. So yeah, that's my farm.
Jenny, a quick follow-up question.
Sure.
Sorry, my audio is a little messy, it seems. Just tell us a little, does it matter as a small farmer in relation to genetically modified crops? What's been the experience?
A small farmer, I think a lot of it depends on if you're talking in the US or globally. So I am part of a group of farmers. We're in the Global Farmer Network. And from a technology standpoint, the farmers that I am involved with are in South Africa, in Nigeria, in Kenya, in Bangladesh, India, the Philippines, and really seeing the technology as being scale neutral, which is different from the way we really look at it in the United States. So it's not so much the technology, it's the application of the technology. And I think in the US for small farmers, it probably is more of a challenge in terms of expense related to their operation. And whereas in South Africa, one of the farmers I'm very familiar with is very keen on making sure the technology is allowed to be used in South Africa, because he has seen real benefits from it from a management perspective as well as a yield, and therefore his food security for his community. So I think in terms of technology, it's somewhat scale neutral, but I think it's the application of the technology that varies in different regions.
Great, thank you, thank you. Our fourth panelist is Dan Charles. He's a science journalist and currently National Public Radio's food and agriculture correspondent. In his coverage of farming and the food industry, Dan focuses on culture, business, and the science behind what arrives on our dinner plates. Among other highlights of his career so far, Dan has published 2 books, including Lords of the Harvest, Biotech, Big Money, and the Future of Food. Dan?
Thanks for inviting me. So I'm a journalist, not an academic and not exactly a practitioner. So, what I have to offer is stories and not necessarily, kind of carefully researched conclusions. One of the things I've always wondered about, it's kind of a thought experiment with no good answer, is what would have happened in the alternative case. Let's say the Supreme Court had decided something different. Let's say that patents had not been allowed on living organisms. How would the world have been different? And it sort of raises the question, like how transformative was this decision? How transformative was, since we're specifically talking about agricultural biotechnology, how transformative were GMOs? And my feeling about this has been that the companies involved in this industry have kind of wanted to have it both ways. They have wanted to argue on the one hand for the purposes of patenting or for the purposes of raising money from investors that this was transformative, that this was all fundamentally new, completely different, human-made invention, could not have happened in nature. So, give us your money. We're a good investment. We're doing something new and amazing here. But then when it comes to dealing with the public and regulators, they've wanted to argue something completely different, that this is simply the same thing that people have been doing for thousands of years, developing new plant varieties. This is just like plant breeding, they would say. So in this tension, is it transformative or is it just the same as what we always had? I kind of lean toward the side that it was not so important. So yes, it was, these specific technologies were adopted amazingly quickly by farmers. So that's evidence that they were like new and different and valuable. But on the other hand, I mean, it's 30 years after companies started working on biotech crops, and the number of actual usable, valuable genetic traits that farmers are planting is tiny. It's remarkably small compared to the promises that were made in the early 80s. I mean, fundamentally, you have one family of genes that has been used for insect control. Some of those genes have lost their effectiveness already because of insects developing resistance. And then you have the genes for herbicide tolerance, the famous Roundup Ready trait, now supplemented by other things, glufosinate tolerance, dicamba tolerance, that family of genes. So did it make a difference? I mean, you asked the National Academy of Sciences, and they assembled, sort of data on trends in crop yields, for instance, and they say there's no clear evidence that it made a significant difference in the historical trend. Certainly it made farming easier for a lot of people and allowed farmers to expand their operations. So that made a difference. So just put that aside for a second. The other thing that has struck me in writing about this over the last 20 years or so is, and in this sense, I think the decision was really, really important. The thing that has struck me is kind of like the central importance of intellectual property in people's attitudes toward this technology. I've been struck often, in just writing stories about, for instance, the movement against GMOs, how this is particularly true in the earlier years. So sort of the book that I wrote was about the first 20 years of GMOs, the development mostly by Monsanto. So this may have changed in more recent years, but especially in the earlier years when I think that the terms of the debate were established, I've been really struck again and again how often, like, the people who were most active at the heart of the movement against GMOs were profoundly motivated by opposition specifically to profit-driven ownership of biology, corporate domination of agriculture, seeds, all that kind of thing. So I think, this thing that we're talking about today, I think, was very, very important in the arguments over biotechnology and the way it's been implemented.
Thank you, Dan. That's actually a good provocation for the discussion as well. I appreciate that. Thank you all. That's a great set of beginnings. So I want to lead a conversation now among the panel on a couple of different topics. So let me just start, in fact, picking up with what Dan just left off there, some of the controversies around biotechnology patents. And as he alluded to, there's kind of a category of issues that have to do with issues around the ownership of the code of life, whether it's corporate hands or even a set of discussions, understandably, about kind of a dominance of advanced industrialized countries over developing countries, concerns about bioprospecting, about developing countries having, natural resources basically taken and then modified in advanced countries and then sold back to them in some form. There's been a second set of concerns around the safety and industrialization of the food production system in the US and worldwide. Does this wipe out small farmers? And Jenny, that was a bit of what I was getting at in the question to you, but you might follow up here. And then there's a third set of concerns, in a way very ethical, about shouldn't there be some limit somewhere to what we engineer, to what we create out of life technology. So I basically want to actually invite each of the columnists, each of the panelists to comment on one or more of those points if they would like to. Wave your hand. Yeah, Dan Kevlis.
Well, before I get to that, I wanted to just comment very briefly on what Dan Charles just said. I absolutely agree that the use of genetic modifications in agricultural production has been very limited. So far as I know, a lot of what I know about it comes from your book, but that's my impression. I'm glad to hear you validate my impression. But in principle, in practice, the major uses in agriculture have been to the benefit of agribusiness, that is to growers. And maybe Jenny can comment on this as well. That is like Roundup Ready. So it allegedly reduces costs and so on by making the fight against pests more efficient, rather than to use it to enhance, say, consumer health by introducing vitamins, for example, into foods that are consumed in vitamin deficient areas, or other forms of nutrients that would benefit the consumers as distinct from agribusiness. But I do want at the same time to add a point that's important to bear in mind, even though our panel is focused on food, and that is the patenting of living things was enormously consequential in the area of microorganisms. The Stanford's patent on the recombinant bacteria produced by Boyer and Genentech was not granted until after Chakrabarty. And that's because the microorganisms that were used to produce first somatostatin and then insulin were part of the patent. And so the use of microorganisms, genetically modified microorganisms in producing pharmaceuticals has been enormous, and by any measure, by dollars, by consequences in the healthcare system, and so on. So it's important to bear that sector of biotechnology in mind. To come to the third world business, there is a TRIPS agreement, Article 27A, I think, that says that the third world countries have to establish some sort of protocol for protecting intellectual property. And they have been, I think, pretty eager to do that. They don't object to they object to being exploited, but they don't object to having patents on these things. What they want is a cut of the action. And so they have established intellectual property regimes that makes them kind of biotechnology capitalists, biotechnological capitalists, just like the rest of the world. How those benefits are distributed or not distributed, or equitably or not equitably within their own countries, is another story. But the patents themselves, it seems to me, have been largely embraced by third world countries.
So I've long asserted that it had the original technology come out with a consumer-oriented trait over an agricultural-oriented trait, that we'd be in a very different position. We might actually have more traits, like Dan alluded to. We have a very limited number of sort of events that are beneficial mainly in terms of grain production for agriculture. And I think that would be a very different scenario had some of the earlier traits that came out actually be consumer facing rather than farm facing. Having said that, we do save seed. We actually bought a tractor trailer load of barley from our neighbor the other day because that's what we use for planting cover crop. So the difference for us is if something's in the public domain, you can save seed. And if something's not in the public domain, whether it's organic, conventional, or biotech, you can't save those seeds. So it's not really a biotech issue in terms of being able to save seeds. It does go back, obviously, to the patents, and that applies to conventional biotech and organic seeds across the board. And I think that also speaks to the fact that what has come down to is there are so many limited options in the public domain because universities have cut way back on agricultural research. It's just not the investment on the public side of developing those, and it has become, the focus has been on the agricultural seed businesses, which has resulted in the limited options. I will clarify, though, that we would never have saved hybridized seed to begin with, because as you regenerate those seeds year after year, they lose their traits. So no farmer would save a hybrid corn seed. Well, they could, I guess, before they were patented, but you would eventually lose the benefit of even the hybridization. And so that's, for us, it is a higher seed cost compared to, say, seeds that we buy that are in the public domain. But then you look at what does it cost to then manage that crop? And I'll use our tofu beans as an example. So they are conventional, non-GMO soybeans. Look like any other soybean. Driving by, you wouldn't know the difference. But because they are not Roundup ready or herbicide resistant in any way, you actually have to sort of front load what you're going to apply for weed control ahead of time before they emerge from the ground, because once they've emerged, there's very little options for controlling weeds across the field once the plants have come out of the ground. And so that's when you revert to some of the older, not so soft chemistries that you can use for weed control. Your other option is to do cultivation. And we've been predominantly a no-till farm for a very long time. Cultivation is sort of antithetical to how we farm. And here in this region, in the Chesapeake Bay region, for us, tillage is one of the biggest culprits of sediment going into the Chesapeake Bay. And with that goes the nutrients, mainly the phosphorus. When sediment leaves your farm, so does the phosphorus go with it. And so anytime you disturb the topsoil, you run the risk of some type of erosion. And so the more you cultivate to try and control weeds, the more at risk you put your topsoil in terms of getting blown off or washed off through the rain. And again, that's not very healthy for your field, for your soil health. So there's a lot of trade-offs that we have to make on a seasonal basis. I wouldn't say a daily basis, but those are the things that we really have to think about managing on our farm, so that hopefully one of the next Schmidt kids in the next generation will want to come back, and we have maintained the integrity of our farm and our soil health. And obviously, no kid wants to come back to a farm that is losing money. Nobody wants to take over the family business that's in the red. So the economics always fall into that, that as part of the equation and part of the balance of how you family farm in the United States.
That's great, Jenny. Dan Charles, did you want to chime in?
Just to expand a little bit on a point that Jenny made, that one of the things that has happened over the last 30, 40 years, as a result of kind of the rise of intellectual property in this sphere, and I know more about agriculture, I'm not as familiar with sort of the pharmaceutical side of these things. Dan Kevles' point, I think, is absolutely right about the importance of the Chakrabarty decision and intellectual property in microbial, sort of the use and manipulation of microbes. But in the world of plants and plant breeding and plant genetic resources, there's been sort of a very slow, I don't believe in some of the horror stories around intellectual property and the effects that it has had on individual people. There are some horror stories which are more mythology than real about kind of, sort of corporate domination. But it is true that, as Jenny mentioned, it's not just GMO seeds that are patented these days. Pretty much every seed company patents every variety. And so the same rules now apply as, that Monsanto originally sort of pioneered when it came out with its Roundup Ready soybeans to restrict seed saving and restrict kind of competition. That is now typical in the seed industry. And that has implications for the relationship between between private industry and public research. Researchers now have a much harder time even getting into that game. Their access to the latest variety, the latest generation of seeds, even to carry on further research, is very limited, unless they sign all kinds of, sort of agreements that tie the product of that research to the owner of the intellectual property that they're using. On a global scale, it has had implications for the sharing of plant genetic resources, the seeds in those seed banks. Seeds in many countries that are held by national seed bank systems are not available for sharing because countries have reacted to the privatization of plant genetic resources here in the US and the corporate sort of commercialization of them. They've reacted by saying, oh, you're going to take the things that you historically claimed from our continent many, many years ago, and you're going to commercialize it now under these restrictive rules. Well, you're not going to get that anymore. So access by researchers and also companies, unless they sort of, try funding arrangements, access by public sector researchers to those nationally held seed banks has been restricted. I mean, and that is all part of this story. I think I should just stop there.
Dr. Chakrabarty, I wanted to ask you, so first off, everyone, there's a very active set of questions coming in. We're delighted to see that. We have over 270 people participating. I will not be able to ask the panelists 270 questions, but please do continue to submit your questions. It's wonderful to see. We will get to as many of them as we possibly can. Dr. Chakrabarty, I was just curious, your view on the role of intellectual property systems for developing countries. I know you've been active and participated in some of these discussions in India and elsewhere.
Intellectual property is very important for, let's say, bringing a product to the market or helping a country develop its research base and all that. So I'm all for encouraging research and development, both by the developed countries as well as by developing countries for the benefit of their citizens. So.
Great. I've had a couple of people ask a question, why was your genetically modified organism never used? And do you know why hasn't there been a commercial product like it to clean up oil spills?
Yeah, the problem at that time was that there was a lot of fear, rightly or wrongly, about what the genetically engineered microorganisms can do if the genes from the bacterium that we that we plan to use for oil spill cleanup or for any other purposes would move from the original bacterium to other neighboring bacteria, some of which might be might be disease-causing pathogens and similar problems. The problem was we couldn't definitely argue that these plasmids cannot be passed along to other microorganisms that were pathogenic because we had no data and plasmids can be transmitted to any microorganism. So the problem was lack of information that would allow us to actually go ahead and answer those difficult questions like what would happen if the ability to digest hydrocarbons in oil would pass from the original bacterium that was designed to be released into the oil spill to other pathogenic bacteria resident in or near the oil spill. So it's our inability to address these difficult questions that prevented us from actually getting permission from the governmental agencies to actually go ahead and use the bacteria for cleanup of oil spills.
Thank you. That's really interesting. I wanted to do a third kind of big topic before we get to some of the other questions from the audience. So, since 1980, we're really looking at this 40-year window, but then also thanks to Dan Kavalis looking at a 90-year window since 1930. The U.S. innovation system has really changed considerably, right? So we've gone from an era in which a large company like General Electric, which at the time had thousands of scientists, GE still does, but it had thousands of scientists pursuing an incredible array of topics, into an era now where companies have fewer scientists, but we have far more startups. So we've gone from a model which was really about, large R&D organizations into government support for research, a huge amount of information flow between and startup company flow between universities and the small biotech and other small tech sectors, with a lot of risk-based capital from venture capital and other investors to kind of help those firms grow to a certain level. And then, of course, a huge drop-off, a huge amount of projects never get to market then, or a huge amount of startups fail ultimately. There's a statistic that there's been on the order of about 4,000 biotech companies in the US since the mid-'80s. But of course, 200 to 300 of them fail a year, which means we have that many new ones being created. It's an amazing churn. But it's a really different kind of innovation system than we had prior to the 1980s. Of course, part of it had to do with the Supreme Court decision to allow patenting. Another part had to do with the Bayh-Dole Act to allow university recipients of federal funds to also patent. So I'm just curious, people's comment on this notion of how the US innovation system has shifted and what some of the implications have been. Dan, please. Dan Kavalis first.
Great question. I'm not sure I agree with the premise of your question in the sense that the large corporations are no longer major players in the game. It's probably AT&T, for example, is not, but that's because it's no longer a monopoly, and so Bell Labs went the way of the dodo, and who knows what DuPont, et cetera, are doing, but I think they're continuing. Places like the big chemical companies, Monsanto is biotech, but not only in biotech, et cetera. I also think that you need to keep your eye on the newer industries, such as software. Google Facebook. They have huge R&D enterprises within their company. So I think that you're right, though, in the sense that the number of small startups has multiplied enormously, and that makes a different kind of game that whose characteristics we don't fully understand. For them, the patent system is essential because when they go out to raise venture capital, what they have is talent and a patent or a small patent portfolio. And without the patent portfolio, they're not going to get anywhere in raising the venture capital. So at the same time, patents have also served as they have historically since the second industrial revolution in the 1880s as weapons of corporate competition and warfare. So the patent system is not only an incentive and an enabler of innovation, it's also an enabler of cutthroat competition. So I think that that has to be taken into account when you look at the system of innovation. Universities certainly play a major role, and Bayh-Dole was very important. But it's not only that Bayh-Dole did not only enable universities to patent things, which they had been able to before by agency decision, like NIH, Department of Defense, and so on. It made the system uniform across the government, was what Bayh-Dole did. But it also said that they have to license these things out to, after what good is a patent to a university? It's not a development corporation. So they have to license these things out. And insofar as universities have been, interested in funding themselves through innovation and patent licensing and so on, that has contributed to the system of innovation enormously. At the same time, there are those who argue that it distorted the research enterprises of the university. So it's as you rightly say, it's a big, complicated system. But I wouldn't write off or assume, as a matter of course, that major players are not still in it. They're just different. They're not GE. And by the way, going back to GE, it's interesting to note that I interviewed Ananda a long time ago, and I wrote an article on Simon v. Chakrabarty as to what happened in GE, why they would why would they seek a patent on a living organism? Nobody thought of doing that because it was assumed you couldn't because it's a product of nature. And when he encountered the vice president, I forget his name, on a Saturday when you were coming in there, the vice president says, "Oh, we should get a patent on this." And you said, "Well, you can't patent a living thing." And the guy says, "Why not?" And that was the question, why not? And the Supreme Court said, yes, why not? Okay. But it's because the culture of GE was patent everything, right? But they were newly into the area of biology, right? And they didn't think differently about biology from the way they thought about jet engines, right? So that's why this came up. It's because it was in GE. If it had been in Lilly or Roche or any of the other drug development companies at the time, I don't think it would have happened.
This is not a considered opinion, but you brought up the Bayh-Dole Act and the role of universities in patenting fruits of research and licensing it to companies. I've been struck by looking at some cases of this, how haphazard the process seems to be. So all these universities have these offices where they employ lawyers and technology experts to go through the very involved process of helping formulate patent applications, pursue the patent applications, get things patented, negotiate with companies, try to solicit companies. I mean, it's a lot of work. And my impression is it yields, in most cases, very small returns, except for these isolated cases where they get really big returns. And they earn lots of money from a very small number of patents. A few institutions do. So it strikes me more like some sort of lottery than a like smoothly functioning system to promote innovation and commercialization. I see you saying something, Dr. Kevlis.
The observation is acute, but it also has to be historically modified a little bit. As soon as you know, patenting and all that, Mary-Dell was passed, every university worth its salt opened a patent and licensing office. And for about 10 or 12 years, they all ran at a loss. But beginning in the 90s, as the biotech revolution really began to take hold by producing profitable products, I mean, especially in the pharmaceutical area, the patent and licensing offices began to earn enough to pay for themselves and beyond. And as you say, there have been spectacular successes, but I think on average they do operate at a profit. It'd be worth an article. See like you I don't think they would.
Empirical question.
I don't think they would keep going if they were just operating at a loss.
Yeah, I would love to do that story. Airtime these days, for some reason, is very, very limited. I'm not sure I'd get it on the air. Just one other small observation. This is again from the world of plants, and it's just a story that kind of stuck in my head. So there's a plant breeder at Washington State University who he became a plant breeder later in his career, but he was in the department that deals with apple trees, and creating a better Washington State apple industry. And he spent most of his career working on sort of this new like dwarf trees and trellis system. So sort of the modern apple orchard looks more like a vineyard, and it's these small like 8-foot high things on a trellis, and it's super high yielding and easy to harvest and all that. No, goodbye freestanding big apple trees. And it transformed the industry. It's really, really important. It's not something that you would ever get a patent for. It's not something he would ever earn the university would ever earn royalties from. But it happened. It was innovation. It was disseminated easily. Okay. Late in his life, he became a breeder. And he was the person who selected the apple variety the original, tree that we now know just commercialized as Cosmic Crisp. It's the hottest new thing in the apple business. They patented it. They also trademarked it. And the real value there is the trademark, not the patent, because the trademark never expires.
Right.
And if this thing takes off as they expect it to, it's going to earn the university hundreds of millions of dollars. I mean, vastly more than the apple breeding department needs or knows how to spend. It's going to be a huge money earner. So there's this weird imbalance between something that you can assert intellectual property over, the plant variety or the apple variety, principally through trademark, and this trellis system of manufacture, which is probably more important and more valuable to the industry.
Yeah, well, let's bear in mind that a patent is, as you say, finite in years, right? It lasts basically 20 years now from time of filing. But a trademark goes on forever, but a trademark only protects the name. It does not protect the thing. But somebody could produce the same thing and sell it under a different name, and they would be viable legal competitors, I believe, to the University of Washington.
But in that sense, the plant variety, the 1930 Plant Protection Act, in that sense, it was a failure because it didn't actually stimulate the development, successful commercial development of, in this, at least apples varieties. It was only when like the marketers, in more recent years seized on this trademark idea and said, the key is consumers in the store have to look for our name and then we can charge extra for it. It wasn't the genetics that made the value, it was the marketing And so that's what set off sort of the proliferation of these new apple varieties that you see in the store now, you know, sort of the envies and the.
So you're talking right about the Jonah Gold or the Pink Lady, and so people begin to look for them by name.
Pink
Jenny,
Lady, Pink Lady was the first. Yeah.
Jenny, I wonder if you can comment on that, yeah, from the farmer producer side. You know, when you make decisions about crops, how influenced are you by, you know, information you have about what consumers are buying when it comes to things like an apple variety? Obviously, we don't do the same thing for soybean, but tomatoes, there's a certain amount of kind of heritage varieties brand name as well, right?
You're talking to me?
Yes, sorry.
So I have to clarify for the tomatoes that we grow, they're canning tomatoes. So ours are not fresh market, they are field grown. We harvest them 35 tons to the acre and they get hauled up to Pennsylvania and made into spaghetti sauce and salsa and that kind of stuff. So I don't really have a whole lot of experience in the fresh market arena of tomatoes to be able to really answer that.
But to the broad question of, you know, when you make choices about which seeds and crops to plant, are you thinking about the name associated with it?
No, really. I mean, well, I take that back. Wine grapes, yeah, because most people don't walk into a winery or a bar and ask for something that they don't know. So they're more likely to ask for Merlot or Chardonnay or a specific variety of grape, which oftentimes they don't even realize that's actually a grape variety. They thought it was the name of the wine, but it's based on the name of the grape. So in that instance, yes, that dictates to us, the winery customers that we have, what we've decided to plant specifically for that industry. As far as from a consumer perspective, that's really the only crop that we grow that would really kind of have that influence from a consumer side of things. The other ones really, I mean, commodity feed goes to Purdue or any of the other chicken integrators here in the Mid-Atlantic region, with the exception of high oleic soybeans. So I think the trait for high oleic is an RNAi, correct me if I'm wrong, the more science-oriented people. But that's a soybean that Purdue is specifically asking growers in the Mid-Atlantic region to produce because they use the soybean meal for feeding the poultry, but they extract the high oleic soybean oil and refine it, and they sell it on the food manufacturing side. So oftentimes when you now see food products labeled as trans fat free, it's because they're no longer using hydrogenated soybean oil, but they're using a high oleic soybean oil, or in some cases, a high oleic canola oil, because both of those crops that produce a food oil have been bred to produce a high oleic oil. And so that has a consumer application, but it's more because they're trying to remove trans fats from product formulation than necessarily a consumer demand side of things.
Jenny, that's great. I think Dan Kevlis has his hand up. I'll go to him, and then I have a question I want to draw in from the audience.
Yeah, I think there are a lot of questions from the audience we can get to. I happen to be finishing a book called On the History of Intellectual, the Engineering and Ownership of Life from the late 18th century to now. So I know a lot about this history. I just want to mention that the issue of nomenclature has been a problem in plants and seeds, fruits, since the mid 19th century or late or earlier. What I've heard, some of the new, just the recent exchanges, is this reminds me of the nomenclature issues, what names to use for apples, grapes, and so on. And basically, they amount to various strategies or tactics of market competition. You know, people will do whatever they can in order to establish and maintain a niche in the market. the problem was so bad that in 1848 to 50, the fruit growers in the United States formed the American Pomological Association. Pomology meaning fruit breeding. And the first thing they did was to establish a committee on synonyms, because there were so many synonyms for the same apple. Let's say 27 different synonyms for one apple, and these were just weapons of marketing, because people would take the same apple and rename them and sell them. So what's going on is to be expected. It is a latter-day expression of that phenomenon, and I think there is no perfect solution to it whatsoever.
I just want to make a clarification. When you asked me about consumer, I didn't really, I explained the size of our farm when I started. I usually use the term, we're a grocery store farm. We don't deal with consumers at all. You can't come to my farm and buy anything from me. We grow ingredients. That's what I explain to people. So my neighbors who have a farm stand and a large fruit and vegetable operation for consumers would probably take into account those types of names of tomatoes, or those who are having a direct consumer relationship, selling at the roadside stand or going to farmers markets. But that's not the size and scale of our operation. So I just wanted to clarify that.
That's really helpful, Jenny. I have a question I wanted to ask. I want to start with Jenny and then open up to anyone else. So a number of people have asked the question in the sidebar in the chat about the situation that has arisen where some farmers were prosecuted even by seed companies. There have been issues about gene drift between crops on some fields and into a neighboring farmer's field. And so especially related, of course, to some of the genetically modified crops. So I'm just curious, I mean, not that you've had personal experience, but just your perception of that series and how that has impacted farmers.
Yeah, I don't think there's been any incidences of gene drift. And the reason I can fairly confidently say that is because when we were certified organic and had biotech crops, biotech corn and organic corn, and we have organic neighbors who are dairy farmers that grow organic corn for silage. It's not, so of all the crops that we grow, corn is the only crop that open pollinates. Everything else self-pollinates: tomatoes, green beans, grapes, soybeans, wheat, barley. Many crops actually don't need pollinators. They self-pollinate. Corn is an open pollination, so it doesn't necessarily just need bees or pollinators. It can just pollinate with its neighboring corn stalks, but the pollen is only viable for about 18 to 24 hours. And unless you have tornado-like wind, it doesn't travel. It can, and that's a lot of times when you see these articles in the news about the potential exists, yes, in a hurricane situation, if you have very high wind volumes. But under your normal 10, 15 mile an hour winds, your pollen's not really going more than 50 or 100 feet. So to manage that, if your neighbor is organic, like ours is, or when we were organic, it's a matter of timing. So you plant things so that they don't pollinate at the same time, and therefore you don't end up with cross-pollination. What that requires is you have good neighborly relationships, and you have open communication with your neighbors. So a lot of those types of issues could simply be avoided by, being considerate of your neighbors and talking to your neighbors and understanding each other's operation, so that you take that into account when you have a planting schedule.
So Dan Charles has his hand up.
Very, very quickly. I don't know if the questions that you're referring to had to do specifically with the idea of a company suing you for pollen drift. Was that because that is a story that's out there that is kind of in my short list of urban myths. There's only one case I know of in which it is asserted that Monsanto sued a farmer for GMO pollen blowing in from a neighboring field. In this case, it was canola, and it was up in Saskatchewan. That story is quite complicated, and it is not just Monsanto sued the farmer because there was pollen drifting in. And it's so what I would say is I am not aware of any case in which a biotech company has sued a farmer for inadvertent and unwanted pollen drifting in from a neighboring field.
Dan Kevlis.
Yeah, I think that's the Schmizer case up in Saskatchewan, and it is complicated because he was an agent in using the stuff that had drifted onto his land, but it did drift. He didn't go out and steal it. So it is an issue of equity. But I think that apart from suit, the Monsanto's action against Schmizer and the fact that it's a gargantuan company with infinite resources compared with your average farmer has had a very chilling effect on what farmers will do. Monsanto has a kind of police force that it sends around, wires into what farmers are doing with their seed, where they're getting it, and so on. So I've seen a documentary on this. I think it was pretty reliable. So it's not only just the suit, it's also the intimidation. Yeah.
Okay, thank you. We have enough questions to probably go for another 3 or 4 hours, but we actually just billed this to go till 2:30, and I want to reiterate, we are extending it a bit with some samples and items from the Smithsonian collection, so I will encourage people to stay around. At this point, I want to introduce Sean O'Connor. So Sean is a professor of law and executive director of the Center for Protection of Intellectual Property at George Mason University's Antonin Scalia Law School. His research focuses on intellectual property and business law, with particular focus on startups and commercializing technology-based innovations. Sean?
Hi, thanks, Arthur. So this has just been a fantastic panel, and we want to thank the Smithsonian LemelsonCenter for hosting this with us, and we've had a great partnership, as Arthur mentioned before. We look forward to many more of these. It's just a great forum. And thanks to the panelists for giving your time, and to the participants for all their great questions. I thought what I might do in concluding remarks here is to maybe clarify a bit from the pure patent law side about what's going on in this case. And so let's distinguish between different kinds of patents. And what I mean by this is there's actually different statutory sections. So even though we might talk about patents in different industries like software or biotech or things like that, at the highest level, you have to realize that the major class of patents, when we talk about patents, are utility patents. And utility patents do have some limited constraints on them. And so standard living organisms were not generally patentable under utility patents, not because they were living organisms, but because if they were breeded in any kind of conventional way, they were not seen as being taken out of the state of nature enough. So let me pause on that for a moment and introduce that there was 3 large exceptions to patentability that came to the US system from the old British patent system. And those were things that were naturally occurring, things in the state of nature, or laws of nature, like E equals MC squared or F equals MA. And then the third category is abstract ideas. So those were never in the statute, but instead they were in case law that came out of the British system and then adopted by US judges. So I mention that, and it's important because we don't really know the exact contours other than through the case law. So these are kind of living, breathing, changing categories to say what's in the state of nature. To get something out of the state of nature, and this case law still goes on today, it really has to be pretty extensively changed. So we normally were thinking about taking things out of the state of nature by isolating or purifying chemicals, molecules. And so there is some evidence that maybe there was some early bacteria and other things might have been patented, and Dan Kevlis might have more information on this than I do. But it seems that, again, there was no prohibition on living organisms, but taking things out of the state of nature was difficult. So the rulings had generally been that if you just hybridize plants or animals in conventional ways, pre-genetic modification, pre-genetically engineered rather, then they weren't out of the state of nature enough. This becomes a key part in the Chakrabarty case because the opponents of patenting were saying, well, wait, why did the Plant Patent Act have to arise? Why did the Plant Variety Protection Act have to arise if things were patentable underneath utility patents? And so the issue there was that because regularly hybridized plants, sexually and then asexually modified, were not seen as out of the state of nature enough to then be granted utility patents. So what Congress does under the Plant Patent Act is to say, okay, sidestepping that, we're going to give you a slightly different set of rights. So realize that plant patents get a different set of rights than utility patents do. But we'll allow for asexually reproduced plants because they breed true to type enough so we can describe them accurately, that they will then get some of these rights, even though they may not be out of the state of nature enough for a conventional utility patent. Sexually reproduced plants are almost never going to breed true to type in the sense that they'll have different coloration, different features, because they sexually reproduce each generation. And so then we had to bring in the Plant Variety Protection Act, which gives still a different set of rights. So the PVPA breeder certificates are different, more limited than plant patent rights, which again are different from utility patent rights. So this was all critical in the development and in this case. Now keep in mind though that Dr. Chakrabarty's bacteria are genetically engineered. So now this means that they are clearly out of the state of nature because genetic engineering, almost by definition, is doing something that nature could not have done on its own. So again, conventional breeding, you're kind of nudging nature, but it's still the reproduction is happening the way it normally would have in nature. Genetically engineered, you're doing things that nature just would not have produced. So that's why the Chakrabarty case becomes a test case. Why does it come about when it does? Well, because now we have genetic engineering by that time. So Cohen and Boyer and some of the other things that happen, now suddenly you can genetically engineer stuff. And so in some ways, it's not shocking that Chakrabarty's case comes about when it does. And then it has to settle this question. Well, if it's genetically engineered, it doesn't even need to, it wouldn't, if it were a plant, it wouldn't even need to stay in Plant Patent Act or Plant Variety Protection Act. It could just go into straight utility patents. Okay, so let me just, I don't want to go on too long here, but so keep in mind that even after the Chakrabarty case, that still doesn't necessarily open the door for, I saw a warning sign. I want to make sure, am I still coming through, Arthur? Yep, Arthur's not responding either. Okay, I'm going to keep.
Out a bit, but your audio is great. So
Okay, good. Sorry, I just got this local warning sign from my Wi-Fi connection. So still today, if you're conventionally hybridizing things, you probably still cannot get a utility patent. You won't get the same patent that Dr. Chakrabarty got on his genetically engineered. You'll be looking to the Plant Variety Protection Act or the Plant Patent Act. Okay, now let me get into a couple of the thornier questions then that people often raise with this case. And so even if we do have patents on life forms, are we then concerned about what's going to happen with, you know, controlling people, organism, things like that? And so the issue there to keep in mind is that patents are very much a right to exclude, and they don't give you proactive rights to practice something, and they can be overridden by other laws. So the quickest example I usually give is FDA regulation. So if I'm a pharmaceutical company and I have a patent on a new drug, I actually can't go out and sell the drug in the US until it's been approved for sale by the FDA. And so in this way, then, we have to always look at the interaction of patent law with other laws. So in the nightmare case that people are always most concerned with, let's say somebody gets a patent on all or part of a human, then suddenly could we control that person? And the answer to that is generally no, because we still have prohibitions on indentured servitude and slavery. And so it's not going to necessarily give what you think. So there are limits to the concerns that sometimes we have about getting patents on things. Now, a couple of other things that came up in the questions, and we don't really have a lot of time to address them all, but one of the other lawsuit areas that some of the seed companies and biotechs have done against farmers is not necessarily the genetic drift part, and I don't know enough, but it just sounds right to me that these are kind of more urban legend than anything else. But the ones that very much happen were like Bowman v. Monsanto, and that's a question as to what you can do with seeds, or rather reproducing from those seeds when you have purchased them from a seed company. And so if they're patented seeds, just like in the Bowman versus Monsanto company, then that Supreme Court ruling was saying that, okay, you buy the seeds, even if you get them from a different place and you don't actually have the bag tag license directly from the provider, then you can use the seeds, the first generation seeds, for whatever you want, for eating them or doing other things, feeding them to animals. But once you try to reproduce those, use them to create new plants, now you're not using those actual seeds anymore. You're creating a new plant, and then that's prohibited. So that's those of you who might be thinking about the biotech cases, seed companies going against farmers. That's generally what it is. We don't have time to go through that, but I'm happy to talk to anybody about that case offline. A couple of quick notes on university tech transfer offices, a subject I've tracked myself quite a bit through historical research. As I think Dan Kevel has mentioned, they existed so long before. Tech transfer didn't originate with Bayh-Dole. Instead, it was there. The different agencies, as he said, had different rules. Bayh-Dole was just meant to make those more uniform. But the important issue is that Bayh-Dole was not intended, and no one intended for all tech transfer offices to be revenue positive. Instead, the issue is, how do we coordinate the intellectual property that's coming out of universities, try to get it out in some useful way, which in many cases could be non-exclusive licenses or even just free dissemination. So even though a lot of tech transfer offices do at department or just to the inventor, it goes to the university overall for the research mission. I would also then say two more thoughts before I then turn it back over to Arthur. There was a mention, I think maybe that the PPA was sort of a failure until trademarks really took over. But I think that it's important to note, as Jenny was saying, that in plant patents, in my view, and breeder certificates under the PVPA were not really designed to incentivize what's called business to consumer. It instead was business to business. So in that sense, then with new varieties under plant patents or under breeder certificates was basically being sold, their innovation that then is sold as an idea to the farmers because they know, oh, okay, this crop will work better for my climate or whatever it is, have different features that then I in turn can then use to be a more efficient farmer and then sell on to the consumers. But it is true that when you want to get more consumer demand, the trademark business definitely helped quite a bit. And then finally, let's just distinguish, there was some mention in the comments about geographic indications. That again becomes a very huge topic as well, but trademarks and geographic indications are separate things. The US has been slow to the geographic indication game, partly because until things like Napa wine really took off and became major industries, we didn't have the same kind of terroir products and things like Europe and other places do. In Europe, it was always incredibly important that the wine was produced with certain grapes in certain soil by a certain method. In the US, we hadn't been thinking that for a long time. So we're late to the GI game. We're getting there, but that's a very different kind of issue from trademarks. All right, let me wrap it up there and turn it back to Arthur.
Excellent. Thank you so much. I see we still have over 200 participants, which is exciting. And at this point, we're kind of formally ending the panel, but we're beginning our add-on bonus. So what I'd like to do is do the add-on bonus, and then we'll do a kind of round of applause for everyone. So at this point, I'd like to introduce my colleague, the Smithsonian curator, Peter Leopold. Peter is a historian of American business and of technology history. He's curated over 10 exhibits, including the major American enterprise exhibit that we are very eager to invite you to come see once the museum has reopened. It is hopefully not too much longer. In the meantime, it's great to have him here to do a kind of virtual tour of some key artifacts. So turning it over to Peter, and Devlin, you can bring up his slides.
Thank you, Arthur and panelists. That was really great to hear about patents on life. What I'd like to do is go to the first slide, Devlin, and you can see that we have a lot of interesting objects related to the fact that nature isn't really very natural. Starting here at the bottom, you see a small pack of seeds. Every industrialized country was roving the world looking for germplasm, finding great stuff. They distribute the seeds to farmers. Jenny talked about her test patch of corn. Here you would have tobacco, probably transported from a different country, and possibly to use. You see the people like Funk Brothers who are hybridizing like crazy, are changing things and pushing the necessary litigation. But the really beautiful piece, the outboard apples, I think goes to what Daniel Kells was talking about in terms of branding. And there are a few apples that certainly are important. The Red Delicious, the Golden Delicious is a variety that's patented, but different growers would trademark their name. So outboard might be a fungible apple. It might be an apple that everybody else eats, but you would like theirs because it's branded and it's just like a soap product. You'd be buying the name rather than the variety itself. To the next slide. The science is really important. We talked a little bit about university scenes. Here you can see Stanley Cohen, who is person who really developed a lot of the recombinant DNA book. His lab book there on the right that gives you the sense of what a scientist actually does. Really an incredible piece. But perhaps even more interested is the reproduction of his lab that we did in Science and American Life. And you can see it's pretty simple, that it's not that terribly elaborate. It would be interesting to hear people talk about how these science labs in the universities have changed over the years, whether they're really the same, and how capital intensive they've really become.
Dr. Chakrabarty, actually, could you take a minute? I mean, when you see this notebook and you see what Cohen's lab looked like, what did your lab look like at GE? And I mean, did you keep a handwritten notebook as well?
Yeah. It's, all labs are more or less similar. And I miss my GE lab. I still have my office at the University of Illinois, but not really any lab, because at age 82, I'm retired and don't have a lab for conducting R&D. But I go there, I go to my office and I talk to people and I keep myself engaged in what's going on with regard to research in biological areas, Thank you.
Dr. Chakrabarty, could we have your lab notebook? Can you pry that out of GE's hands and put it in the Smithsonian so that we can share it with everybody?
Not right now. I mean, right now I'm in a retired home and I'm just listening from my bedroom.
Well, maybe somebody at GE will hand it over to us, because it would be nice to be able to preserve that along with other equipment. Let's go on to the next slide. This is a pair of gene guns. We've talked about genetic manipulation, and there really are different approaches. Gene guns are a very crude way to get new material into a plant. The one on the right is John Sanford's gene gun. He's the person who really came up with the whole concept. He was the interesting backstory is he was having a war at home with squirrels, and had resorted to pellet guns to try to keep the squirrels away, and that became the aha moment that he applied to how you could get actually change the the plant itself. So he created a gun to shoot DNA into new pieces. He was using onions because it's a very big anatomy and works fairly well. And everybody at Cornell would talk about how it made them very hungry. It smelled a lot like McDonald's because he was shooting the onions all the time. The Argacetus prototype gene gun on the left came out of Wisconsin, and this is actually the gene gun that was used to do the prototype work for Roundup Ready soybeans, and it was cobbled together with leftover parts. You can see a big pieces, power sources from an old radar station, high voltage that look incredibly dangerous. If you can't imagine anybody really handling things like this, but I think that in science, people often take some chances that you wouldn't take at home. They also used pieces from the snack machine that the potato chip bag, the Mylar, became a very good piece of the gene gun. So this notion of cobbling things together in science to create parts is really an interesting phenomena. Next slide. Here we have some of the luminaries in terms of genetic change. Of course, Barbara McClintock, you can really starts the whole genetic engineering awareness. That microscope is actually in the Smithsonian collections. Robert Fraley there in the middle did his pioneering work at Monsanto on petunias. And then finally, Mary-Dell Chilton on the right is known as the Queen of Agrobacterium. She did her work at Washington University in St. Louis and was instrumental in really teaching Fraley a lot of what he did. Both Chilton and Fraley used Agrobacterium to genetically modify plants rather than a gene gun. Chilton often talks about how she didn't use the gun. We have a very active program going on right now at the Smithsonian with collecting both from Fraley and from Dr. Chilton. So it's very exciting to really get some of these artifacts from the important beginnings of this time period into public collections. Next slide. This is the product that I hope somebody will find and give to us. Really the first commercial genetically modified product was the Flavor Saver tomato by Calgene. And they licensed it to Zeneca and produced a tomato puree, very popular in England, actually, from 1996 until 99. 98 it starts to become unpopular. But we've never been able to find a can. So hopefully somebody has one tucked away in the back corner. But before people were worried about genetically modified food, you can see in this where the can says made with genetically modified tomatoes. So it was actually very popular. Next slide. And in the avenue of things that you might not think would be in a Smithsonian or museum collection, we have actual seeds. On the far left is a field test of wheat where trying to figure out whether in fact the microorganisms would move within a field, where they would drift into another field or not. This is a big concern, and one of the huge costs of doing genetically modified plants is the safety tests. This was a test that was done at Clemson, and they found that there was very little movement of the microorganisms. The seed souvenir in the center is Roundup Ready soybeans, released in 1996. This is a promotional advertisement that a lucite block that dealers gave away. And then finally, on the far right is the plant itself. This is the genetically modified petunia plant. This is a seed from that 1983 plant. that we was saved and actually grown out. So there you can see a important early genetically modified plant in a museum collection. So it's kind of an unusual piece. Next slide. Protest is something that's really important. Some of the questions that came in were about concerns. There's certainly a lot of fabulous stories. Mark Linnaeus's book that came out recently, Seeds of Science, talks about how some of the conspiracy stories and concerns that were raised by people don't have a good founding in science. There's a lot of talk today about truth and the biotech field is filled with issues that revolve around this. But protest comes in many different forms, from buttons to refrigerator magnets to legislation. The Yes on 522 was an attempt to pass laws. Next slide, please. And then our final piece goes to what Jenny was talking about with no-till. That no-till is soil conservation practice instead of plowing a field for weed control, that you do very limited or no tillage at all. And what this means is that you're not going to get a lot of soil runoff, which is really important. Farmers hate weeds. Weeds choke out plants. They're the enemy of the farmer. So early on, people used poisons in order to stop weeds, of course. No-till was a practice that certainly was in use before genetically modified herbicide-tolerant plants, but with the advent of the herbicide-tolerant plants like the soybeans Roundup Ready or the Maximizer corn seed sac is actually a BT. It speeds up the process. So the whole concern about poisons is something that's really important. It's a very big cost point for farmers, and poison control is certainly a big issue. So there are a few artifacts from the collection. I wish you could have shown them to you in real life, but at least you got to see them online. Thank you very much.
Thank you very much, Peter. And we are now really well above time. I really want to thank the participants. It was an amazing turnout. There was no way to get to all of the questions. We could have spent 2 days doing this, and maybe in the future we should. But I want to end here, but I would like the panelists to unmute themselves and give a round of applause, particularly to Dr. Chakrabarty. Thank you so much for joining us. Thank you for really getting this whole area going. It's really remarkable.
Also to Peter Liebold, and I wonder whether we can get copies of some of those artifacts you showed.
We can certainly share the slides. You don't get the actual artifacts. They don't leave the building. Absolutely. And yeah, Dan, as I saw a couple of questions in there about when your book is coming out. It seemed like there were a number of people interested. And yeah, if there's any images you need for that, we're happy to help you.
It's called Vital Properties, the Engineering and Ownership of the Stuff of Life. And it's going to be published by Knopf, and I hope next year, 2021.
All right. And yeah, I mean, there are a number of other experts have written wonderful works on this. Sean, maybe we'll put together a little reading list for people who are interested of some of the key works. And again, thank everyone. I really want to thank each of the panelists. Appreciate you taking the time. And with that, I'm going to declare a formal end of the panel, and wish everyone a great afternoon or evening or night if you are joining us from around the world. Thanks so much.